Welcome to a brief tutorial on legal sources. By the end of this tutorial, you should be able to identify authoritative legal sources. Just as with regular research, there are different types of legal sources. They can be categorized as primary or secondary, but as with any discipline, what fits into those categories may be different from what you know from previous non-legal research. In the law, primary sources are the actual legal sources. In other words, the law itself. For example, cases, statutes, state and federal, constitutions, and agency decisions and regulations. Secondary sources are those that interpret or analyze the law. There are a variety of secondary sources. Following are some of the most well-known. For you, not a lawyer, and maybe not even anything related to a legal studies major, the main legal sources you need to worry about are those primary legal sources and law review articles. A lot of the other sources, for example, treatises and American law reports, contain detailed legal information which may be hard to understand, but it can be helpful to at least have heard of them. Secondary sources are things like treatises. Treatises are books, often multi-volume sets, that cover specific areas of the law in depth, such as copyright law. Dictionaries, just like a regular dictionary, only focused on legal topics, and some with references to cases or laws. Legal encyclopedias, like Wikipedia, only focus specifically on legal topics. Note, just as with any research, you normally do not cite to sources that give you background information on a topic. Rather, you cite to the sources that help you build and support your argument, like cases and law reviews. If you would like to cite to a dictionary or encyclopedia, you might want to check with your professor first, as other sources might be more appropriate. Secondary sources include ALR, American Law Reports. ALRs are written about cases that represent emerging, unsettled, or changing areas of the law or legal issues. The annotations are often called articles and are written by legal scholars, using the case as a basis for the annotation. Restatements, which are a set of treatises on legal subjects that inform judges and lawyers about general principles of common law. Articles from law reviews, which are scholarly articles just like in any discipline. Note, it is important to know that there are different types of law reviews. There are articles written by lawyers and legal professors versus notes written by law students. You'd want to use articles if at all possible versus notes. You can easily distinguish them by looking at the title. See the note indication as well as the author information, which doesn't really tell you much about who they are. In contrast, the article says article, and the author information clearly states their qualifications. Continuing of secondary sources, there are government websites and statistics, non-legal scholarly articles, for example, from a related discipline, such as political science, or interdisciplinary, such as women's studies. NGOs, non-governmental organizations. These are non-profit organizations that operate independently of any government. Typically, their purpose is to address social or political issues and problems. And think tanks. Think tanks are bodies of experts providing advice and ideas on specific political or economic problems. Now let's review some sources and see if we can identify what they are.